Welcome to the Widener Wordsmith, a podcast series designed to enhance and supplement legal methods here at Widener University Commonwealth Law School. I am Pam DiMartino, an adjunct professor of legal methods and the host of this series. Joining me throughout this year will be attorneys from both academia and legal practice who will provide listeners with advice and insight into the challenging process of legal writing. Welcome back, 1Ls, to the second episode of the Widener Wordsmith podcast series. I'm Pam DiMartino, and today I'm joined by Professor John Dernbach, author of A Practical Guide to Legal Writing and Legal Method, one of your required textbooks for legal methods this year. Hello, Professor, and thank you for participating in today's discussion of legal writing.
Thanks. I'm glad to be able to do this.
This is wonderful. I want to start our talk today by sharing with our listeners how I came to officially meet you. I met you somewhat informally the week prior to orientation week when I spent some considerable amount of time with your textbook, looking over the assignments that were going to be reviewed in the course of the legal methods course. And then when I was told that my office was ready, I came into the law school and was walking down the hall and, dropped my things to open my door and glanced across the hall. And there you were sitting at your desk, and I saw your nameplate. And I just thought, wait a minute, how do I know that name, John Dernbach? And it was sort of one of those eureka moments when I realized, my gosh, the guy who wrote this textbook that I'll be working with my students all year is sitting right across the hall from me. And there you were. And we were able to meet and talk and chat about your experience as a writer, and that's why I'm thrilled to have you today, because I'm hoping you'll be able to share some of that experience and insight with our listeners as well.
And I'll try and do that.
That's good. Well, let's start off with that point, and that is the textbook is one of the three that is assigned to first years as part of their legal methods course. And I'm hoping then, as we're talking through here, we can discuss perhaps its history. Let's start off with, how did it come about that you decided you're going to be a textbook writer?
By accident. That's actually the truth. I went to law school with the idea of doing environmental law, and that should be no secret to you or a lot of other folks.
Absolutely not.
And I had a job lined up after law school, but it wasn't going to start until about a good solid year after I graduated from law school. After I graduated, in other words, the American Lung Association in Michigan had an idea of hiring a staff attorney to do clean air work.
All right.
But they hadn't created the job yet, and they hadn't gone through the board approval process and budgeting and so forth to create that. And so I taught legal writing at Wayne State University Law School in Detroit for a year right after I got out of law school. And what I found was that the materials that were available at the time weren't very helpful. Mm-hmm. As I recall, the writing materials that existed then fell into two different categories about legal writing. One, if you breathe the air long enough, you'll get it.
Right.
Two, grammar for lawyers. And those particular approaches did not help me when I was grading papers. And I remember the first set of papers that I got, it was 55 students, 3 or 4 page memo, the problems that I saw in the memo had very little to do with the way I had been, the materials that were in the books that I was supposed to use. And so I started thinking about also, how do you grade these papers? Mm-hmm. And I'd heard, of course, about 100 times, you just throw them down the stairs and all those silly things that people say about grading papers. And the ones that go the farthest get the high grades, or maybe it's the ones that go the farthest get the low grades. You can go all sorts of ways with that. But I felt like I needed to grade with more integrity than that. And so I started trying to figure out what I was grading for. And then you say, well, to myself, I said, so okay, I can tell the students to get organized, but what does that mean exactly? And after talking to a number of people, it seemed to me that organization meant about 4 different things. Discussing each issue separately, discussing each sub-issue separately, describing the law before you apply it to the facts, and explaining your position before you explain other positions that you didn't agree with and that you didn't take. Well, when I had that, I had something I could grade with. But I didn't have that until I really started grading. So we had what you might describe as kind of an awkward moment when I handed the student papers back because, 1, they didn't do very well, and 2, I was using a lot of criteria that they hadn't seen before. And so beyond, and they had plenty of opportunity to get better over time, and most of them did. But when the year ended, the absence of a really solid text bothered me a lot. And I got more engaged with the issue of how do you teach legal writing than I ever expected to. One of the insights I got as I taught was that the use of examples and exercises was incredibly helpful to teaching. You can lecture forever, and you can lecture as effectively as you possibly can, but if you can't get the students to do the things you want them to do, then you haven't succeeded as a legal writing teacher. So the original idea, we got a small grant from Wayne State University at the end of the school year, and the original idea was to create a set of exercises. And what we found out right away when we started writing the exercises was that if you don't provide the students with some guidance about how they ought to answer the exercises, you're not really going to have an effective product.
Right.
And so what emerged from that was the teaching strategy that the book employs. The teaching strategy that initial round of material and subsequently the book employs, which is you explain a particular principle, like discuss each issue separately.
Yes.
Okay. And you explain why it matters. You show the students good and bad ways of answering a hypothetical question. Then you explain why one way is better than the other. And then you give exercises at the end to enable the students to take what they've learned and to practice getting it right. And so we got this material, and we put this sort of a prototype of the textbook together at the end of the summer. And then we thought, well, this is really interesting. I wonder if we could publish this. So we went to the Wayne State Law Library, and we asked them for all the textbook publishers. And they said, well, here's a list of 8. And they gave us these 8 textbook publishers, and so we wrote them all a letter. And every single one of them came back no, except one. And that was the Fred B. Rothman and Company in Littleton, Colorado. And what happened there was that they didn't publish texts. If the librarians had known that, they wouldn't have given us Fred B. Rothman's address.
All right.
If we had known they didn't publish texts, we wouldn't have sent them the letter. They're in the middle of dictating a letter to us saying we don't publish textbooks. Fred Rothman, the publisher of the company, the president of the company, changed his mind.
Wow.
And so we wound up publishing the text with him with that company, small company, in 1981.
So
now,
they took a risk.
They took a risk. They were mostly a library services company, and they had never published a text before. Now, what happened then was that text got to be the best-selling legal writing book in the country by the end of the 1980s. And it did that, I think, because as friends of mine who have been career legal writing people have pointed out, it did some things that hadn't been done before. It blended legal writing and legal method, which had not been really, those two things had not been combined before. It broke down the pieces of legal writing into separate, discrete steps,
Yes.
explained each of them, as I just mentioned a few minutes ago, and used a building block approach so that within a fairly short period of time, you can take a student from not understanding any of this to writing a fairly effective piece of legal writing.
Yes.
That's what we did, and we did it when we were really young.
Just starting out with your careers.
Just starting out with our careers, yeah. But I got my first copy of the book about the time of my 28th birthday. And I think there's some value, actually, in your 20s of not knowing that something can't be done.
So you weren't deterred.
No, I wasn't deterred by how it can't be done. That didn't, because we had an idea about how to do this, and we did it.
That was the first edition.
That was the first edition.
And the copy of the text that the students have now been assigned is the 6th edition.
Right.
So how did that evolve now over the course of these years? Because you're no longer a professor of legal methods.
No, I taught legal methods, legal writing at Wayne State. I've taught it here, but I don't primarily teach legal writing. And so the strategy that we've employed for and Rich Singleton, by the way, is a partner at Blank Rome in New York.
Mm-hmm.
So, we're not career legal writing people, but Rich, by the way, was a colleague at Wayne State, and so we started out together. But in any event, what we've done is we've brought people who teach legal writing into the process. So we have Catherine Wasson has been with the book for a while,
Mm-hmm.
And before her, Kathy Wharton and Joanne Rutenberg. And so for the last several editions have involved those folks, and now with the 7th edition, which we just started work on last week, we're going to bring Amanda Schultes into the project. And so
For our students to realize that's another one of our faculty members
right,
here.
for another one of our faculty.
Yes.
And Amanda's smart, hardworking, very creative, and I'm looking forward to having her participate in that. But the core of the book is a student-centered approach to legal writing.
Yes, it is.
We don't start with the idea that that what we have to say is the most important thing of all. What we start with is some understanding based on quite a lot of experience shared among all of us.
Mm-hmm.
That teaching legal writing in little pieces is important, that explaining every single step is important, that showing people what to do is important in advance, giving them opportunities to test their skills, and then doing it over and over again. The importance of practice. All those things, I think, make it a student-centered book.
Well, and it also exemplifies the writing process itself, that, the writing is not once and done. It's not linear. We've learned that it's recursive, and it requires drafts, it requires evaluation and revision. And
one of the hardest things when you're starting out in writing, especially in law school, is recognizing that it's harder than it looks. And it's not any different than what you see if you watch any kind of sports, if you watch any kind of music, if you watch anybody do anything well. Those people, male or female, athletes, musicians, whomever, all make it look easier than it really is. And the idea here, I think, in legal writing and in learning legal writing and in entering that space, if you will, is to recognize that, like anything else, it's hard at first. It's not all that much fun at first. And you need to put in a lot of time and effort to get better at it. But
Right.
as you get better at it, it becomes more fun.
Well, it allows for more creativity on the part of the writer.
and that too, yeah, all and that, and as you get better at it, the exercise of your skills is something that is something that you come to look forward to.
And so, as students are picking up their syllabuses and starting to realize then they have assignments already, perhaps you could share some insight on how they should approach their chapter reading. For instance, my experience last year was that certain students, because of their experience from college, they treated it as sort of a narrative textbook where I would just read through chapter 7, highlight some ideas, and then move on, and then just read the next chapter and move on. And I don't believe the model, as you're discussing on the writing instruction, lends itself to reading this book in that fashion.
No, this is a how-to book, and straight up a how-to book. And if you don't recognize that right away, then it's going to be a lot harder. Learning law and learning legal writing is a whole lot more like learning math or science or any other class where you have to apply yourself. Frankly, driver's education and keyboarding are reasonable analogs here. If you have memorized the text, but you cannot do it, then you do not know it.
Oh, I get it.
And so the point I was making a few minutes ago about the importance of practice is not a small thing, it's a big thing. And what part of the difficulty in teaching law school is that, and certainly in being in law school for some people with a certain undergraduate background, is that there's a certain set of habits that have to be unlearned. One that I tell my property students is, and I would say in legal writing as well, is if you leave the assignment, if you leave learning this stuff to the night before the paper is due or the night before the exam, you won't be here anymore. What you really need to do is keep working at it and practicing, because like anything else, even driving and keyboarding, you don't get this stuff automatically.
No.
It doesn't come naturally, and it takes time to learn it. And the only way you can really master this stuff is just to keep practicing. And so doing the exercises, figuring out what other students have done on the exercises, and figuring out what you did well in the exercises and didn't do well in the exercises, all of that is really important. And the sooner, I would say to the students who are listening, the sooner you do that, the better off you're going to be. The longer you prolong that, the longer you're going to prolong real learning. And by real learning, I mean learning that enables you to actually do what is being taught, whether it's a legal memo or a judicial opinion or a brief of some kind. You can't do any of this if you haven't really learned the material.
And as you said, along the way, in the small, focused learning segments, and particularly the segments that you have in the book where you give examples of a strong piece of writing, something that they should, work towards, but then also giving them a weaker example and inviting them to really examine them to figure out why. Why would this one piece of writing garner a higher score if it's all about the grade? Then why am I going to get more points for this type of writing than I am the other? And I found that very helpful in the chapters last year of modeling more than just here, this is what's exemplar, but giving somewhat the weaker pieces so that they can start to identify and evaluate that themselves.
Well, and I think that's important precisely for the reason that you've described. It's one thing to say this is good legal writing, It's another to contrast that with bad legal writing, and so people understand that. And the critical thing here is the end point. There are two end points that the book is directed toward. One is just basic competence in writing the kinds of documents that are contained in the book. All right, and the second end point is documents that the reader can actually understand without a lot of difficulty. One of the things that students and lawyers need to be mindful of is that the people who read the documents that you write as a lawyer are busy people. They've got a lot going on in their lives. They don't necessarily regard you or your work product as the most important thing that they're going to be doing that particular day.
So
and
true.
they're not particularly friendly to having to work really, really hard to figure out what you mean.
Mm-hmm.
And so the orientation of the book is toward writing documents that are no more complex than the material itself, and that do not contain a lot of artificial barriers to understanding, like lofty, highfalutin legalese, long sentences, convoluted analysis, and that sort of thing. We're looking to help students write documents that will actually achieve results on behalf of their clients, precisely because they're easy to understand.
Well, let me digress somewhat here then. In addition to the Practical Guide to Legal Writing and Legal Method, we also have another book in the stacks here at the library and available to our students, Writing Essay Exams to Succeed in Law School.
Yes, and I would not have written that, and I could not have written it in that way if I had not first taught legal writing. What happened not too long after I arrived here, I taught at Wayne State for a year, worked for this environmental group for about a year and a half, and then started working at the Pennsylvania Department of Environmental Resources, as it was then called, for about a dozen years, little more than, before I came here. And when I came here, then Dean Geddes asked me to teach property, which I was happy to do. But he also, but what happened as soon as I started teaching legal writing, or started teaching property, I began to think about, well, how am I going to evaluate the students? And it's one thing to teach adverse possession or gifts or whatever it happens to be, to teach the cases involving that. It's quite another to figure out how to teach them how to write the exam on which their grade will be based and on which much of their future depends. And it
It's
began
sort of the same conundrum that you had earlier.
It's the same conundrum. And what I learned in teaching legal writing is that the process you employ is you show the students what you want, you explain it in great detail, you evaluate them based on that. And that's the approach that you take. You don't evaluate them based on something that is entirely new or different, or even partly new and different from what they've already heard and seen. So I wrote a 2-page memo on exams, which turned into a 20-odd page handout. And students started coming to me and saying, I passed the bar exam because of this. My grades got better because of this. And I thought, okay.
You're onto something.
Yeah, exactly. Maybe it's time to see if I can prepare a short book. And so that was the point of the exam writing book. And I have to say that what keeps me going on the exam book is not that I keep wanting to do additional, new editions of it. It's that the feedback I get from the students is really quite extraordinary. And so that's why I keep at this. It's when I was in law school, the great mystery was how you write exams. There was no book that said
There was not. I would agree.
Yeah, there was nothing. And so when you wrote an exam, I mean, the best advice I got was from second and third year law students in the hallways at law school. And I don't think that's a fair way to teach this material.
No, not very effective.
I don't think that's the right way to set people up for the rest of their lives in terms of their legal careers.
So we'll let our first years know, although it's not required of their legal methods class. I highly recommend that they take a look at this particular publication. Again, it was Writing Essay Exams to Succeed in Law School and Beyond.
Yeah, and beyond.
Law school and beyond. Well, Professor, I apologize, but we have come towards the end of our session, and I'm wondering, do you have any closing remarks or parting pieces of advice that you would like to share with our first-year students?
Seize the day. This is a challenging experience for everybody. Even the people who do well here are deeply challenged, and it's a lot of work. But if you work hard, if you pay attention to what you're told, if you make corrections, as you will need to do constantly, you can do quite well here in terms of setting yourself up for a legal career. There was a young woman in my legal writing class the first year I taught here, and she was in my office one day, and she was really upset, and she says, there's this other guy, Matt, and he is so smart, and he just does so much better than I do, and it's just not fair. And I said, look, just keep doing what you're doing. Keep working at this. I reminded her of the story of the little engine that could.
Yes.
Which is still a good story. I saw her a couple of weeks ago. She was with her daughter and a cousin of her daughter's. She is she's a prosecutor now.
Wonderful.
For a local DA's office. She has an exceptional track record, and she's doing very well, thank you.
Yes.
And this is someone who had deep doubts in law school about whether she would succeed. And she dealt with that by simply working hard and doing the best that she can. All you can do is the best that you can.
And for many, it's certainly enough.
It's certainly enough.
Well, again, I thank you for your time in joining me today and sharing the wealth of your experience here with the writing and the publication of your book. And I look forward to speaking with you again.
And I look forward to talking to you again. And frankly, if any of the students want to talk to me, I'm happy to do that.
I'm so glad you said something, because I'm hoping that I can invite them to contact you through your school email address.
Yeah.
Stop by your office. Want them to realize you are here. Right? You are an author in residence.
Happy to do that. That's very kind. Thank you.
Thank you.
This podcast series was made possible by a generous grant award from the Association of Legal Writing Directors and the collaborative and creative support of the Legal Methods faculty at Widener University Commonwealth Law School.
Widener University Commonwealth Law School is the Pennsylvania capital's only law school, with 3 specialized centers of legal scholarship through its Law and Government Institute, Environmental Law and Sustainability Center, and Business Advising Program. Widener Law Commonwealth offers an exceptional learning experience that is personal, practical, and professional. Visit commonwealthlaw.widener.edu for more information.